Hi, Attorney Andrew Bethel. We've covered a wide range of topics on this channel under the umbrella of estate planning, probate, funding a trust, long-term care planning, taxes, and more. In combination with our great viewers like you, we've received some great questions in the comments on our videos. We try to answer each one, but also figure, well, if one person is asking, then it's likely someone else has the same question. With that, today we're going to tackle questions on bank accounts in your living trust. All these questions come from the comment section of our video on how to fund a trust and transferring bank accounts to your trust. But first, be sure to like the video, subscribe, and ring the bell to stay up to date. Also, leave a comment below if you have any questions or have a topic you wish for us to cover. But as always, thank you very much for watching. First up is a question on whether cash accounts inside a trust are FDIC insured. Yes, trust accounts are FDIC insured. For those that may not know, the Federal Deposit Insurance Corporation is one of two agencies that supplies deposit insurance to depositors at American banks, the other being the National Credit Union Administration for credit unions, and for which the same insurance coverage applies. Thus, whether it be a bank or credit union, the same deposit insurance is provided. Now, the coverage on that insurance for a trust account depends on how many beneficiaries there are in the trust. For each beneficiary, there is $250,000 of coverage applied. Keep in mind, there are typically two instances where your beneficiaries might change: when you amend your trust to change the distribution, or when the trustors pass away. For example, my wife and I have a trust together. Since it is a normal revocable living trust, the trust is to operate for our benefit during our lifetimes, meaning she and I are the current lifetime beneficiaries of our trust, and thus any trust account we open will have coverage up to $500,000, $250,000 for each of us. However, if both of us pass away and we leave everything to our son, he becomes the sole beneficiary at our deaths. Thus, the coverage at that point would only be for $250,000 while he wraps up our estate. Next, we have the question of whether business accounts go into a trust and what kind of trust that I recommend when needing to hold a business in trust. Business accounts are typically treated a little differently than a normal trust bank account, as they are owned by another entity, that being, well, the business itself. Thus, the only parties that can be on a business bank account are the owners and authorized managers. However, keep in mind that the value of one's business is included when determining whether an estate qualifies for probate or not. So a question then arises: if a business and the money held by it cannot be held within a typical trust bank account, how do we avoid probate if the overall value is above the probate threshold? Well, if you own a business and are creating a trust, you should assign your interest in that business to your trust with a document called an assignment of interest. This would allow for a trustee of the trust, yourself or your successor, to manage business affairs such as bank accounts, as the trustee technically would be the manager of the holding entity, that being the trust. This means the business is in trust and thus is not counted when determining whether the assets held outside the trust are subject to probate or not. Additionally, we have seen some banks allow for a non-owner manager to be on a business bank account, so you should always speak to your banker for their personal requirements. To answer the follow-up question as to what kind of trust I would recommend when needing to hold a business in trust, it's going to depend on the situation and whether we're planning with a certain tax strategy in mind or with charitable organizations. However, for the overwhelming majority of situations, a normal revocable living trust is going to be the best option here. You should make sure your trust has provisions for management of a business within the trust terms so that the trustee has explicit authority as to what they can do when managing a business. Our trusts have that language by default, but talk to your attorney if you aren't sure if your trust has those provisions. Finally, we have the question of what needs to appear on the title of a bank account for said account to be in trust. Simply put, any bank account you want to hold in trust must have the name of the trust on the account. Even when the trustee changes, the name of the trust itself stays the same and thus is the most important aspect to keep on the title to the account. In theory, you could have a trust account with only one of two trustees on title to that account, but that would generally defeat the purpose of having co-trustees to begin with, or if you're doing a family dynasty trust, which is way beyond the scope of this video. Thank you for watching. If you enjoyed the video, be sure to check out some of our other excellent videos here, but don't forget, hit the like button, subscribe, ring the bell, and tell us what you'd like for us to cover down in the comments below.